This video will be dealing with appeal from orders. That is, the decree is generally appealable according to section 96, but orders are not generally appealable. But orders are appealable on certain circumstances, so such situations where appeal can lie for an order are given under Order 43 of CPC, and it is dealt under section 104 to 106. So, what are the circumstances in which appeal could lie for an order? There are total 18 situations. I have dealt only with important orders, that is, orders for payment of compensatory cost. In case the court orders any compensatory cost under Section 35A, such orders can be appealable. Orders in case of public nuisance or public charities. So, in such situations, which has to be read along with Section 91 and 92, such situations, order can be appealable. Orders under Section 95, that is, court has ordered for any compensation, whereas the party aggrieved has been arrested or detained, or the court has made an attachment of his property, and even injunction has been caused, and harass has been made on insufficient grounds, to put simply. In such case, the aggrieved party can claim for compensation, and the other party should pay the compensation. In such case, even such orders can be appealable. And orders imposing fine, arrest, or detention, such orders can be appealable. And other orders that are appealable under civil rules of practice. So these orders can be appealable. It is not an exhaustive list. The total list is there are 18 situations that should be referred in the Bar Act. Section 104 deals with uh, a situation that is, to simply put, orders are appealable, but in no circumstances orders can be appealed for second appeal, right? Orders can never go for second appeal, and that is the statement that is given here. There is no second appeal for orders, but this condition will not affect right to appeal under letter patent. Letter patent in the sense the presidential courts in colonial era has been given certain powers. So in such case, it is not. So this condition will not restrict this right of such courts. And the exception to this condition is Supreme Court SLP in special leave petition under 136, Article 136. Every order can be appealed in the Supreme Court. Review revision, and this condition will not affect review and revision as well. And section 105 deals with orders of remand or interlocutory orders that affect the final decision, that affects the final outcome of the case itself. Then such orders, interlocutory orders or orders of remand, can be appealed. Section 106 deals with appeal will lie before same court where appeal of decree will lie, right? It is as simple as that. Order 43 deals with appeal generally. 43 deals with appeal generally lie from 18 orders, as we discussed before. And some of such examples are orders returning plaint. It is return and not rejection, right? So orders returning plaint can be appealed. Rejecting application to set aside dismissal of ex parte decree, right? Even such orders can be appealed, whereas an application has been made to set aside an ex parte decree. or dismissal of a suit. Even upon such rejection of application, appeal can be made. Setting aside sale or refusal, and setting aside abatement of suit. Abatement in the sense it is stopping the suit. Orders of such nature can also be appealed. And Order 44 deals with appeal by indigent person. So indigent person in the sense he is not able to pay the memo of appeal itself, that is court fees. He is not able to pay that, but his right cannot be denied, right? So therefore he is entitled to appeal, but he should make an application as an indigent person. So there are multiple process that he should go through to qualify as an indigent person. But now there are two situations where he is appearing as a indigent person or pauper only in appeal. That is, he has not been a pauper, he has never been a pauper throughout the case, but he shows himself as a pauper only in appeal, claiming that he is not worthy at all. He's insolvent or he's an indigent person, and therefore he can appear as a pauper in appeal stage. So in such circumstances, a court may after uh, he may be allowed to appear as a pauper, right? He may be appeared as a pauper only after inquiry has been conducted. So when he shows up as a pauper only in appeal, in such case, inquiry will be conducted. And this is first situation. The second situation is that from the very beginning he was appearing as a pauper, as an indigent person only. In such case, there is no need of any inquiry right in appeal, but affidavit to that regard must be submitted to the court. Appeals to Supreme Court. So whenever we are appealing to Supreme Court, it should be subjected to constitutional provisions, rules of Supreme Court, and CPC. Only with along with these three compliance, Supreme Court appeal shall be made. Supreme Court appeal uh, before the Supreme Court can be done for any of these, like for judgment, decree, final order, but it shall only be from High Court. In this situation, High Court must certify that these judgments, decrees, and final orders can only be tried by the Supreme Court. Only then it can be qualified to be appealed in the Supreme Court. So, party to apply for such certification appeal and such uh, uh, such application for certification, that is fitness certificate, must be disposed within 60 days. He can either grant or refuse to give the certificate. And the party applying, the contents are as follows. Like for obtaining fitness certificate, he should submit some applications, right? So in that application, he should mention the grounds for appeal and what grounds he is appealing for before the Supreme Court, and he can pray for fitness certificate. So he should state substantial question of law, as we discussed in previous lectures. When it comes to second appeal or appeal before Supreme Court, it is not substantial question of fact, but it is substantial question of law. Only then the Supreme Court will entertain such suit for an appeal. And such substantial question of law should not be only restricted between the parties to the parties in the case, such issue, but it shall also have a general public importance. Only then, and such suit or case shall only be decided by the Supreme Court. In such cases, the Supreme Court can entertain appeals. So while making such an appeal, an opposite party must be served with notice, and they will certainly make some objections. So after hearing such objections, court may either grant or reject. Once certificate is granted, the appellant must furnish security because certificate of fitness has been granted, right? So this the objective of this provision, that is to furnish security, is that the appellant must not delay the suit. Like, he has so much of remedies and he cannot deny the right of another person. He cannot deny right of another person by delaying the suit itself. And High Court will declare that appeal is admitted, and notice will be sent to the respondent as well. And High Court may transit all the documents, and even High Court does everything in this scenario. Supreme Court will just hear the matter, and all the documents, relevant documents, will be sent to the Supreme Court. So it is important to note that just by appealing, it will not be constituted as it will not be construed as an automatic stay for execution. So the aggrieved person, generally the judgment debtor, if he want to stay for execution, he have to file another application. It is not that it just goes for an appeal and it will be stayed automatically. It is never the case. Supreme Court, along with getting security from appellants, can also do following things. Like, Supreme Court is getting security, right? So along with that, it can impound any movable property in dispute, and it may allow execution with the security by the judgment holder, and it may allow for execution with security by that is the judgment holder. We have already dealt with this provision. And it can stay execution. So execution is being stayed for the benefit of the judgment debtor, right? So judgment debtor will be the appellant in most cases. So in such case, the appellant shall give security. The court may take the security from the appellant, and the court may also appoint receiver or anything that it deem fit. And that is about appeal from orders and appeals by an indigent person. Thank you.